Everyone. Welcome to today's iteration of the live employment law Q&A by employmentlawyer.ca. My name is Teilen Celentano, and I'm an employment lawyer with Samfiru, Tumarkin LLP, and I work at our Toronto, Ontario office. As always, please go ahead and ask your questions directly, however you're watching this, whether through Facebook, Twitter, X, LinkedIn, YouTube, and I'll do my best to answer them live. You can also go to our website at employmentlawyer.ca, email us at help@employmentlawyer.ca, or call us at 1-855-821-5900. So I'd like to start today by talking about two separate topics, each very prevalent to the current times. The first of which is return to office mandates. So as we all know, the pandemic thrust a bunch of changes to everything, and most, in this case, very notably to the labor and employment sector, right? So the people at work. I don't need to remind everybody that everybody was working from home, or maybe not everybody, but everyone who could had started working from home in 2020. And different employers took different approaches to that. Some employers decided this was going to be a permanent change, and others said it's temporary, and others didn't take a position. They just weren't sure. But what we have seen over the course of the last, I'll call it two-ish years, really since the end of the vaccine rollout and when the world started to open up again, is employers are, for various reasons, mandating that their employees go back to work. So naturally, we've had a lot of people reach out to us and ask us, hey, what are our rights? What am I allowed to say? What do I have to say yes to? What can I say no to? This, that, the third. So there are a number of different things that can affect what your rights are in these situations. So first and foremost, if you were working in office pre-pandemic, so before the pandemic hit, you worked in office, and you only started working from home as a result of the pandemic, and your employer never made any representations that this would be permanent, then your employer is allowed to mandate that you return to work. So what we discuss and what I discuss almost every week are constructive dismissals, one of the many topics. And a constructive dismissal is defined as a substantial change to the terms of someone's employment. So the change of working from in office to at home is substantial, but it was necessitated by a global pandemic. And it is likely that if, in that situation I just described, it is likely that it would be seen as a temporary change, not a permanent one. Now, conversely, if when you started working from home, your employer said, look, this is going to be permanent, get used to it. We're going to be working from home forever and ever. And you made decisions based on that. Maybe you moved further away from the office. Maybe you gave up places in daycares, and you live in a city like Toronto where it's incredibly difficult to get a spot at a daycare or anything else. And now that your employer is reneging on that, is changing their mind, and it's telling you that you need to come back into the office, well, then in that case, that is a new change, right? So whereas before you were an in-office employee, you became a work from home employee as a result of the pandemic. When your employer says it's permanent now, that get used to it, that's the new term. And by them changing you back to an office employee, it's likely that could be a constructive dismissal. And that constructive dismissal can entitle you to a full severance package. And again, as I always say, a full severance package can be anywhere from 1 to 3 months to as much as 24 months, depending on the circumstances of your employment. Biggest thing our courts look at, age. How old were you when your employment was terminated, whether it's just a normal termination without cause or when you were constructively dismissed. The second biggest factor is length of service. How long have you been with that employer? And then lastly, the availability of similar employment. So if your employer is making this change, going back on their word and saying you have to come back into the office, then there's a good chance it's a constructive dismissal. And the last situation, the last scenario where we're seeing this is people who were hired post-pandemic. Right. So the pandemic hit obviously it was Friday, March 13th, if memory serves. And that was the day the World Health Organization declared it a pandemic. So everyone started working from home. A number of people were hired after that, April, May, June 2020 and afterwards. And as part of their hiring, they were told it was a work from home position. And unless your employer made specific representations that work from home is only temporary, work from home is only temporary, you don't have to do it, then, or you would never have to come back in, unless your employer made representations that work from home is temporary and that you would eventually have to come back into the office, then it is likely that a court would determine that the working from home, the nature of that, was an implied or an express term of your contract. And now the employer mandating that you return to the office can once again be a constructive dismissal. Another thing to keep in mind, if your employer is mandating that you go back to the office, is that your family status is protected under the Ontario Human Rights Code. So one of the things we've seen frequently is on these return to office mandates, for whatever reason, parents aren't able to find adequate childcare to get to the office on time or to leave on time. Obviously, there's school, but school is only 8-9 months of the year. And, if you're working 9 to 5, most schools are letting out at any time between 2 and 3. So there's a few hours at the end of the day where you can't, where you need to not be at the office so you can pick up your child. So what happens in those cases is employees should request to be accommodated on their basis of their family status. So the family status, that being protected, means the company has to accommodate you up to the point of undue hardship for anything that results from your family status, including childcare obligations. So if you're in a situation where, maybe your employer does have the right to recall you to work, but because of your childcare obligations or also because of your obligations to care for another member of your family, you can't. You can still work from home. You just can't get to the office because of your other obligations. You can request accommodation. And given that you have shown the ability to work from home for years now, the company would be hard pressed to establish that was undue hardship. The second thing I wanted to talk about was mass layoffs and what your rights are in those situations. So unfortunately, given the current economic times, across multiple industries, multiple sectors, we're seeing mass layoffs. So huge portions of employees being laid off in one department, one company, what have you. And in those cases, your rights are still protected. And in fact, in some cases, you actually have enhanced rights in those situations. So the Ontario Employment Standards Act, which sets the minimum bare bones employment standards, actually provides for enhanced termination entitlements in the event of a mass termination. And generally, a mass termination is any time when 50 or more employees are let go at the same time or within a short period of time. But in addition to those entitlements, in addition to those even enhanced entitlements, you can still be entitled to pay in lieu of notice of termination in accordance with the common law. So a lot of words there. So essentially, what the common law is it's the basis of the Canadian judicial system. Well, Canadian except for Quebec. Our country is a common law jurisdiction, just like England, just like the United States, just like Australia and New Zealand, and all the other British Commonwealth countries. And based on the common law, which is comprised of the previous cases that came before it that are similar, employees are entitled to enhanced severance packages, which again can be as much as 24 months. So whether you're being laid off, whether it's just you or it's you and your 49 closest friends at work, you are likely entitled to more than is being initially offered. So if you're let go, don't sign anything. Don't make any representations that you're accepting whatever they're offering you. Go to our website, employmentlawyer.ca. Set up a time to speak with one of our legal reps who will be able to review your package that's being offered, and we'll be able to advise you specifically on what you're entitled to at common law under the ESA and whether or not the package you've got is fair. And obviously, if it's not, then we'll be able to help you and make sure you're getting fair compensation. So flipping now to the questions. So the first question for today is from Manwar on YouTube. He asks, if your pay is garnished by the CRA, is there any way to stop this from happening to severance pay? So this is kind of a twofold issue. Of course, there's a tax component here and an employment law component. So I practice employment law. There are a number of different ways that we can have settlements paid out. But generally speaking, severance is paid out as wages. In a situation where your pay is being garnished by the CRA, there may not be much we could do, but it's always a fact-specific exercise, right? Until I look at the individual facts of your situation, I can't advise definitively, but generally speaking, if the CRA wants something, it's really hard to stop them from getting it. I think we can all attest to that from our personal lives. So, and that remains true with severance pay. But there may be something we can do in your case, Ben, where I'd suggest you reach out to us because again, dealing with garnishment, dealing with the CRA is never something that is easy. Next question on Facebook from Carla. My employer has repeatedly canceled my vacation requests at the last minute because they keep putting me on new projects right before my scheduled time off. I've since requested a different vacation time, but I'm worried this will happen again. I haven't had any time off all this year. Can they fire me if I just take my vacation regardless of being put on a new project? Can an employer stop you from taking any vacation at all? So, I think the easiest way for me to answer is to answer the second question first, and then the first one second. So can an employer stop you from taking any vacation at all? No, they can't. Under the applicable legislation, every employee in Canada, or in Ontario, whether you're provincially or federally regulated, you are entitled to take vacation, and there's minimum standards that they have to give you. Companies are allowed to approve it or disapprove it. They don't have to approve every single vacation request, due to business needs, but they are expected to act in good faith and, approve vacation requests that they can accommodate internally. So no, an employer can't stop you from taking vacation at all. Now, if you haven't had any time off all year, and obviously we're coming up, we're early November now, there's only 2 months left, you're in a precarious spot. You have the right to take that vacation. You're entitled to it. And if the employer is preventing you from doing so, you do have recourse. You can file a complaint under the Ministry of Labor, and you can hire a lawyer to help represent you in that. And when you file that complaint with the Ministry of Labor, there's an express prohibition against the company retaliating against you. So if you attempt to enforce your rights under the Employment Standards Act, and in response to that, the employer tries to punish you, cuts your hours, cuts your pay, terminates you, in addition to what you'd be entitled to for severance, there's additional monies that you'd be entitled to for that retaliation, for that reprisal. I think in your case, Carla, I'd really recommend that you put everything you just said to me in writing to your employer, that this has become a pattern of behavior, that you need to take this vacation, you're entitled to take this vacation, and that you would like to take it from this time. Another important thing to keep track of as well, Carla, is if you're making plans and making payments in anticipation of this approved vacation and the company is then pulling it back, you want to keep track of that and make it very clear that you're now suffering a loss as a result of the company's actions. Again, making it clear, putting it in writing is really important so that if and when you have to go to the Ministry of Labor, you have to retain me or one of my colleagues to help represent you and help fight against the employer, then in that case, we have as much documentary evidence as we can. Lastly, taking the time off without permission is not something I would recommend. Doing that would likely be deemed insubordination. And until you've spoken to a lawyer specifically who's reviewed everything about your employment, I would recommend against doing that because what you're availing yourself to, what you're opening yourself up to, is an allegation of just cause. If just like any other employee who refuses to show up to work when scheduled, if it happens enough, that can amount to just cause for termination. If you just go AWOL, absent without leave. So, Carla, I think in your case, if it really has become an issue, it's something that's been happening perpetually over time, and you can't take the vacation you're entitled to, then I'd recommend you reach out to us at employmentlawyer.ca, email us help@employmentlawyer.ca. Schedule time to speak with one of our lawyers. It sounds like in your case, it's a very situation specific analysis that we would need to undertake. So I think it's definitely best for you to reach out to us. Next question from Emil on Facebook. He asks, if I don't sign the settlement agreement on the litigation date, which part of their agreement am I facing repercussions? So not 100% sure what the question, what you're asking here, but I'll kind of rephrase it. So what I think you're asking is if I don't sign the settlement agreement, so the severance offer on the date in which I'm terminated, which part of their agreement what are the potential repercussions? So generally speaking, when someone is let go, they're offered a package, right? So they're offered a package that typically includes their minimums under the Employment Standards Act and maybe a little bit more to sweeten the pot. Oftentimes when we see that, those offers, even though there's that tiny pot sweetener, they're still insufficient. They're still woefully insufficient to what you're entitled to in court if you hired a lawyer and fought for more. The potential repercussions of not signing it are there, but they're very minimal. The first and the biggest one is that offer might get pulled. The company may choose not to extend that offer if you don't sign it right now. Generally speaking, though, those offers remain open for acceptance, if not, later that day and over the course of about a week, give or take. And the reason for that is if the employers decide to pull that offer, right? So they make an offer to you. You say, I want to think about it. I want to discuss my rights. I want to speak with a lawyer. And they say, never mind, we're pulling it. Well, now they're almost guaranteeing that they're going to be contacted by a lawyer and may find themselves in costly litigation. So, and then the second potential repercussion would just be that it delays it, right? Since you're not signing it right away, it may take an extra week or two to get you paid if you end up taking that offer a little bit later. But other than that, there really aren't any repercussions. And I wouldn't ever let either of those two repercussions prevent you from contacting a lawyer. Almost universally, not all the time, but almost all the time, when someone is let go and they're offered a package, it is less than they're entitled to at law. And people frequently leave thousands and tens of thousands of dollars on the table because they take that first offer. And once that first offer is signed, once that release is signed, as a lawyer, I'm really limited in what we can do. Whereas if you don't sign it, you take it home, reach out to us at employmentlawyer.ca, and then talk to me before signing it. There are a lot of things I can do to increase that package and increase the amount of money in your pocket and help ease the transition from the job you've lost to your next job. Next question from GB on YouTube. I've been on short-term disability for 11 months. My benefits provider made me go for a psychiatric assessment last month. They recommended that I return to work. My psychiatrist agrees. So I agreed to return, but my manager doesn't want me back. If I go back, can my manager hire me at his first opportunity? So no, he can't, GB. So when you are on a medical leave, whether you have disability benefits or not, it is a job protected leave under the Employment Standards Act. And what that means, being a job protected leave, that means that when you are ready to return, the employer must. It's not should try. It's the employer must return you to the same position if it exists, and if not, to a comparable position. So it's the same obligation that happens when someone goes on a maternity leave or goes on reservist leave. If that person goes off and it's a job protected leave, when that leave is over, if that job still exists, even if it was filled by somebody else, they have to return you to it or to a comparable one if it's not. That doesn't mean you were off, somebody else filled it, we like them in that role, and that role still exists, but we're going to put you in this comparable one. That's not the standard. Again, the standard is if that job exists, they have to put you right back in it. So no, they can't, fire you right away. Come back on Monday, fired on Tuesday. That would be a complete circumvention of those provisions of the Employment Standards Act. Second, doing that, letting you go right after you came back from a short-term disability leave, is likely discrimination on the basis of a disability. So, of course, when you hear the word discrimination, you think of the overarching, very clear discrimination, the derogatory remarks, the I'm not doing this because of this. But discrimination is more of that. Discrimination can also be, like in your case, you took a medical leave, we found something, we put someone else in that role, we like them more, so we're letting you go. And that you're in that situation, you're being subject to adverse, i.e. negative treatment as a result of a disability. And that, under the Human Rights Code, is discrimination. And then lastly, an employer can't just let you go for any reason. If your manager decided to fire you when you returned, you would still be entitled to a full severance package. But because they're breaching the ESA, the job protected leave provisions. And because they're breaching the human rights code and the anti-discrimination provisions, yes, you'd still be entitled to a full severance package. You'd also be entitled to additional damages for breaches of the human rights code, breaches of the Employment Standards Act. All that to say, though, if your employer was dead set on terminating you and you were a provincially regulated employee, which the vast majority of employees in Ontario are, there wouldn't be much we could do to get you your job back. Our ability to do that is generally limited. But what we could do instead, in your case, GB, is get you a full severance package, damages for the breach of your rights under the Human Rights Code, damages for the company's breach of your rights under the Employment Standards Act. So if that's what's happening before you go back, I really think it's important you reach out to us, employmentlawyer.ca, so that you can talk with one of our lawyers, one of our paralegals before you go back. Really make sure you have a good game plan, a good roadmap set down before you go back, making sure your rights are protected in doing so. The next question on Facebook is from Jessica D. If employment ends due to a permanent disability preventing an employee from returning to work, they're on LTD, is employee owed severance? So the fact, again, anything dealing with disabilities is always super fact specific. But generally speaking, if someone is on LTD for an extended period of time, or whether in receipt of LTD benefits or not, if someone's on a medical leave for an extended period of time, and it becomes apparent that there's no return to work in the foreseeable future, then that person's employment isn't terminated, but instead that is frustrated. So what does frustrated mean? It doesn't mean we're angry. It doesn't mean we're upset. It is a legal principle that applies in every area of law. And what it means at its most basic form is a contract can no longer be performed through the fault of either party. So when you're in this case, the contract can no longer be performed. The employee cannot go to work, and then the employer, in exchange for money paid by the employer, that's the employment contract. And that can't be done because of a disability, which is a fault of neither party. And when that happens in employment law, you're entitled to your minimum statutory entitlements under the Employment Standards Act. So you're not entitled to what some may say is a full severance package, but there absolutely is an obligation for the employer to pay you something. And the important thing in saying this is that in order to get there, in order for the employer to say, all right, this is what we're giving you, the employer has to follow a number of steps, and they have to do it right. They have to make the right decisions. They have to ask the right questions. They have to request the right medical documentation. It isn't enough for an employer just to say, oh, you've been off for 2 years. It looks like it's permanent, so see you later. That's not enough. An employer has to ask the questions. They have to get doctor's notes. They have to get functional abilities forms filled out. And if they don't do that, if the employer fails to take the appropriate steps, then you may be constructively dismissed, in which case you'd be entitled to a full severance package, again, being up to 24 months. When you're in receipt of LTD benefits, there may be some type of offset, meaning either the insurance company or the employer may get a discount on the amount of money that is payable over the course of that. Again, fact specific, somebody would need to look at your documents. But Jessica, if that's the situation you're in, you're on LTD, you've been off for a while, and your employer's trying to let you go, really important you speak with a lawyer. You can do that by going to employmentlawyer.ca so that we can look at the facts of your employment, making sure you're getting everything you're entitled to, both under the statute and under the common law. Next question from Raymond on YouTube. In a mass reorganization, can the employer just get rid of you, although through an unfair selection process, as long as they give you a severance package? So it depends on the nature of the unfairness. So assuming you're provincially regulated, again, if you are let go, your recourse is to ensure that you've been given enough severance, that you've been paid, given enough pay in lieu of notice of termination. And there isn't much we could do to get that job back unless we can identify something in the selection process that was discriminatory, right? So if they are letting people go, maybe they decided to let people go on the basis of hours worked And then parents maybe have childcare obligations before and after work, and you can't stay late, can't work as many hours, and are therefore constructively be discriminated against because of their family status. Well, that could be discrimination, and that could be something we could leverage. But generally speaking, in Ontario, when someone is let go, there's nothing we can do to get that job back. Instead, we just need to make sure that the severance package is full and fair. Just like employers can let someone go due to a conflict of personalities. It's not discrimination for me to for someone to be let go because they didn't get along personally with their boss, right? So, and that's one common misconception. My boss had it out for me. Well, as long as your boss didn't have it out for you because of a protected ground of discrimination, we're limited in what we can do. Our courts have taken notice of the fact that sometimes people just don't get along. And because of that, employers are able to let people go without cause. That conflict of personality isn't cause. A reorganization isn't cause. You're still entitled to a full severance package. And if that selection process you feel was unfair, but maybe unfair in that you think you should have been retained because you were a higher performer, and it's not unfair on the basis of discrimination, then we may be limited in what we can do. But again, we would be able to make sure you get a full severance package. I'll have one or two more for today, and then I'll wrap everything up. So a question on YouTube from Ron20. Ron asks, what sort of rights do you have when an employer decides they want to retire and stop taking on new work? So Ron, it depends on obviously the nature of the business. Generally, if an employer wants to retire, and we see this often in either small law firms where only one or two lawyers, dentist's office, doctor's office, things like that, where the sole proprietor is really the driver of the business. And in that case, when the employer decides that they want to retire, so the doctor, the dentist, that one lawyer decides they want to retire and stop taking on clients, naturally the work disappears. So when that happens and you're being let go, and your employment is ending, you do have entitlements to severance, right? So an employer could give you notice, so working notice of termination. Ron, where our business is going to close in X many months, weeks, years, at which point your employment will be terminated. Or if they fail to give you notice, then pay in lieu of notice. The second thing as well is that there are some amounts that have to be provided as pay in lieu, have to be provided through a cash payment. Not everything can be provided through working notice. So yes, you're still entitled to severance. And if that's what's happened to you, Ron, it's important that you reach out to us, schedule a time to speak with a lawyer, email us at help@employmentlawyer.ca so that we can take a look at everything. Unfortunately, one of the things we run into in situations like this is that the liability for that severance generally remains with the corporation. It wouldn't follow that one person, that one employer directly, or one doctor, one dentist, one lawyer directly. It's tied to the corporation from which you were employed. My last question for today is from Bree on YouTube. I've been terminated due to misconduct. I've applied for EI, but was denied benefits due to misconduct. I wanted to know if there was any way, to help or appeal to get access to my EI. So I know there are internal appeal processes within that are offered by the Employment Insurance Commission of Canada. You can appeal it to the Social Security Tribunal, the SST. But also, if you've been fired due to misconduct, it's important, Bree, that you reach out to us and speak with one of our lawyers who can maybe even get you a full severance package and then EI afterwards. That's all my time for today. Thank you all for joining. Our next live employment law Q&A will be on Monday, November 11th at 1:30 p.m. Mountain Time with my colleague, Luke Serta, who works out of our Calgary office. Once again, my name is Teilen Celentano with Samfiru, Tumarkin LLP, and I hope you all have a great Friday. Thanks.